Good day everyone, I am Alyssa Marisi Alonde of Y1PMG03 Naphtali, and I will be discussing the Article 1244 and 1245 of the Law on Obligations and Contracts. First, let's talk about the Article 1244. Under the Article 1244, it is said that the debtor of the thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obliger's will. The first paragraph refers to a real obligation to deliver a specific thing. A thing different from that due cannot be offered or demanded against the will of the creditor or debtor, as the case may be. The second paragraph refers to personal obligations, whether it is a positive or negative. The act to be performed or the act prohibited cannot be substituted against the obliger's will. But of course, there are some exceptions. Substitutions can be made if the obligee consents. In facultative obligations, the debtor is given the right to render another prestation in substitution. There is also an exception if other agreements resulting in dation in payment, which will be discussed on the next article, and also novation. The Article 1244 will not also apply in case of waiver by the creditor or substitution is allowed by stipulation with the consent of the creditor. Let's now proceed to the Article 1245. Under the Article 1245, it is said that dation in payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. Dation in payment or adjudication or dacion en pago is the conveyance of ownership of a thing by the debtor to creditor as an accepted equivalent of performance of a monetary obligation. It is a special form of payment because it is not the ordinary way of extinguishing an obligation. A debt in money is satisfied not by payment of money but by the transmission of ownership of a thing by the debtor to the creditor. In order that there be a valid dation in payment, the following are the requisites. First, there must be performance of the prestation in lieu of payment or animo solvendi, which may consist in the delivery of a corporeal thing or a real right or a credit against a third person. Second, there must be some difference between the prestation due and that which is given in substitution or aliud pro alio. And the third one, there must be an agreement between the creditor and the debtor that the obligation is immediately extinguished by reasons of the performance of a prestation different from that due. Take a look at this example. Mr. Han owes Mr. Yuk 100,000. To fulfill the obligation, Mr. Han, with the consent of Mr. Yuk, delivers an artist's painting. If the painting, however, is worth less than 100,000, the conveyance must be deemed to extinguish the obligation to the extent only of the value of the painting as agreed or as may be proved, unless the parties have considered the painting by their agreement, express or implied, as full payment, in which case the obligation of Mr. Han is totally extinguished. Next, as you can see on this slide, it is the comparison of the sales and the dation in payment. First, in sale, there is no pre-existing credit, while in dation in payment, there is. Second, in sale, obligations are created, while in dation in payment, obligations are extinguished. Third, in sale, the cost is the price paid from the viewpoint of the seller or the acquisition of the thing sold from the viewpoint of the buyer, while in dation in payment, the extinguishment of the debt from the viewpoint of the debtor or the acquisition of the object in lieu of the credit from the viewpoint of the creditor. Fourth, in sale, there is more freedom in fixing the price than in dation in payment. Fifth, in sale, the buyer has still to pay the price, while in dation in payment, the payment is received before the contract is perfected, which is to be charged against the debtor's debt. And lastly, 6. In sale, the parties deliver and receive the thing as seller and buyer, while in dation in payment as debtor and creditor. That's it for my report. I hope that you learned something. Thank you and God bless.